to the municipal manager. And the question was whether there is unconstitutionality in that differentiation and whether that differentiation is unfair at all. So I briefly just explained again all of the sections that relate to the municipal manager and then the manager directly accountable to the municipal manager. And most importantly, 54A says the municipal manager is the head of administration of the municipal council. So I wanted to explain that the Act in itself already differentiates, even with the amendments that the committee proposes. There's already a differentiation between the municipal manager and the manager directly accountable to him because of the fact that the municipal manager is the head of the administration. He's also the accounting officer of municipalities. So we must remember that there is already that differentiation in the Act. So it's not as if the amendments that the committee will propose will now bring the only differentiation between these two managers. Then I just went on to section 56 of the, as I said, the Principal Act as it will be amended now by the bill, explaining that the manager directly accountable to the manager is also appointed by the municipal council, but after consultation with the municipal manager. So the municipal manager plays a role in the appointment of the manager directly accountable to him. And then our most important section is the one where we propose amendments to the employment contracts for the municipal managers and those directly accountable to them. And as it is, the Principal Act prescribes already that there must be a written contract for both of them, and they must both have performance agreements. But where the differentiation comes in is that the statute, the Principal Act, in section 57.6, makes it compulsory for the municipal manager to be appointed on a fixed term contract. If we look at the wording, it says the employment contract for a municipal manager must be for a fixed term of employment and up to a maximum of 5 years. And it mustn't exceed the period ending 1 year after the election of the council of the municipality. So it's connected to the municipal council's term. And then in terms of the Principal Act, there was always a subsection 7 that provided the municipal council with a discretion with reference to the manager directly accountable to the municipal manager to appoint that manager in terms of section 57.6. So that would have meant that the municipal council had the discretion to appoint that manager also on a fixed term, for a fixed term contract. And all of the requirements that would be then applicable to the municipal manager in terms of section 57.6 would also be applicable to the manager directly accountable to him. But in terms of the proposals that the committee wanted to do in terms of section 57, 57.7 must be deleted. So that discretion then falls away for the municipal council. And also after the proposal by the Limpopo government, it was proposed that another subsection be inserted that states that the employment contract for a manager directly accountable to a municipal manager must be on a permanent basis. So that now completely takes away the municipal council's discretion, and it makes it very clear that the municipal manager is appointed on a fixed term in terms of the Act, but the manager directly accountable to the municipal manager can no longer be appointed for a fixed term. So if this proposal is accepted, there will be that differentiation between them as well. So the question was now whether this is unfair, and can you hear me? Okay, so we looked at the interpretation of of some of the case law, because what I tried to also explain was because we have because we had the
Chair,
sorry.
they are, Chair, they are cutting. We can't even hear what they are saying now.
You can't hear what they're saying, Honorable. Yeah, can you sit properly or find a location where you can talk properly, Yolande?
Can you hear me now, Chairperson? Sorry, I explained at the beginning that my network is a bit unstable this evening, so I was hoping that I would make it through this opinion. Can you hear me better now?
Let me check with Nkosi Lutuli. Can you hear better, Nkosi Lutuli? I can
Oh,
hear you
it's
myself.
better.
It said it's
Thank
better. You
you,
can proceed,
Chair.
Yolande.
Okay. Thanks, Jay. I don't want to sound as if I'm screaming. Okay, so I just went through a few cases to demonstrate that we've already been implementing some of these amendments when the Amendment Act was still in place. And luckily, there was some judgment that we could also use to guide us in deciding whether these proposals would be constitutional or not. And in the matter of Nongoma local municipality, for instance, it was found that the staff establishment in the Municipal Systems Act, as it currently is, in terms of that staff establishment, the staff are all appointed permanently on a permanent basis. So with the Section 57 discretion that there used to be for the municipal council, that would have been an exception to the staff establishment being permanently appointed. So when the Section 57.7 was taken away, or if it's going to be removed as proposed by the committee, that means that in any case, without us having to insert another provision to specifically provide for the permanent appointment of the manager directly accountable to the municipal manager, it means that that manager would have been appointed permanently in any event. So from the nature of the staff establishment.
Sorry, Chair. The person.
No, this is the legal opinion that was sent to all of you colleagues. So you can check on your documents. There's a legal opinion from the state law advisor. I thought I'm going to respond to the group. I just said she must highlight and summarize that what this. I think this was sent to us. If it's not 3 weeks ago, it should be 2 weeks ago, but long ago. The last time we met, this opinion was there. I think what made us to postpone the meeting, because we couldn't deal with that, we said she must highlight that. And then after that, then the department, because the reason why we adjourned the meeting, colleagues, was that then the department, remember we said they must give us proof that they indeed consulted on this matter. What I've seen, colleagues, is a list of stakeholders that was consulted. So they will take us one by one to tell us if it's ILGM, they consulted on this matter of a manager accountable to the whether that matter was dealt with in that and what was the response. So they will do that one by one. And then I know Salga also want to come in. That's why I said, let's allow Yolande to start. Then the department will take us one by one through those things that they've sent us and maybe help us identify where in the consultation where this issue of managers accounting and what was the response on that one. So that's the route. But the legal opinion is there, Honorable Teza. So she's just doing the summary. If you can then open that document of the legal opinion, as you're saying, maybe Yolanda, as you're talking, just refer to the paragraphs to assist the members. Yes.
Okay.
Thank you so much.
Thanks, Jay. Okay, I think so. In short, what I was trying to explain was just that there is already a differentiation, and that even if we didn't insert the proposed new subsection 7A, that it would mean that the manager accountable to the municipal manager would, by implication, by legal implication or operation, be appointed permanently. So that is dealt with in the Nongoma matter, and that's on page 14 of my and 15 of my legal opinion, where I just explain what the court said. And as I said, they indicated that it's an exception to the staff establishment section, which is, I think, section 66. And then there's another matter also that I discuss on page 16, the Utukela matter. But most importantly, I deal with the constitutionality from page 16 of my opinion, where I briefly just go through the Bill of Rights clauses, the applicable ones, section 7, Section 7, which deals with the rights and that says the state must respect the rights. Section 9, that deals with equality. And then Section 36, which, as we know, deals with the limitation of rights. But then there was a case that I also quoted, which was the Imatu case, starting on page 18 of my opinion, where basically it stated that the law never differentiates between workers that do the same sort of work or are on the same level. And if there is such a differentiation, it must be justified. So that explains that part of the discussion about constitutionality, that where there is a differentiation between two workers or two employees, that differentiation must be justified. And then I refer to the Employment Equity Act, which deals with the prohibition of unfair discrimination. And it says that no person may unfairly discriminate directly or indirectly against an employee. But as you know, there are grounds that are listed in Section 9 on the basis of which we can discriminate. But there's also differentiations that's not based on those essentials that's listed in Section 9. And that is where Section 6.4 of the Employment Equity Act comes in, which is quoted on page 20 of my opinion. And it says that the Employment Equity Act does not state that all employees must be treated equally in terms of their remuneration and benefits. It does permit fair differentiation between employees doing the same or equal value of work. And then the rest of the case law that I refer to is case law that basically explains the differentiation between different employees, and that when there is a differentiation, that such differentiation must once again be a rational differentiation, and it mustn't constitute discrimination. And once that differentiation can be justified, and it's not done in an arbitrary manner, then that differentiation won't be unconstitutional. So that discussion about the differentiation is from page 20, mostly to page 23. And then I also said that once again, as we know, there's already this differentiation in the Act, so it's clear that the legislature intended to differentiate between the municipal manager and the manager directly accountable to that manager. And probably because the municipal manager is the administrator or is the head of the administration, rather, of the municipality, and also the accounting officer. And obviously, due to the nature of the municipal manager's position, there's already such a differentiation. And then also, as some of the cases have referred to the deletion of section 57.7 in the previous Amendment Act before it was declared invalid, it was also clear, and it was stated in the Utukela district municipality matter, that there is this distinction, and that it was an attempt by the legislature to make it clear that they want to do away with fixed-term contracts for managers directly accountable to municipal managers. And that was found in the Utukela matter, and it was also mentioned in the case that I mentioned earlier by the court, to just say what the reason would be for differentiating between those two managers. Chair. Okay, so that just led us then to the conclusion that it cannot be said that that differentiation is unconstitutional or unfair because it is justified in our opinion in terms of the fact, the fact that there is already a differentiation in the statute and the reasons for that differentiation. Okay, so that was basically then our conclusion from page 30 to 31. That was now on the differentiation. And then the next question, I just want to verify those pages. It's page 25 and page 26. That's where the conclusion with regard to the differentiation is dealt with. And then our next question related to the powers and the rights of the municipal council in terms of section 151(2) of the Constitution. As I mentioned earlier, if the proposal to delete the current section 57(7) is accepted. Can you hear me, Chairperson? Chairperson, may I proceed?
Yes, proceed.
Okay. If the section 57(7) is deleted, that means that the discretion that the municipal council would have had to appoint a manager directly accountable to a municipal manager on a fixed term contract in the same way that the municipal manager is appointed, that discretion will then fall away. So the question was, to what extent would that have an effect on the right of the municipal council in terms of 151(2), which states that the executive authority of a municipality lies with the municipal council. And basically, we must remember that although the executive and legislative authority of a municipality is vested in the council, that power or that right of the municipal council is exercised in terms of section 151(3), subject to national and provincial legislation as provided for in the Constitution. So although the municipality should be allowed to govern its own affairs, there is that provision in the Constitution that states that that right is still subject to national and provincial legislation. And then I refer on page 27 to the Democratic Alliance versus Masondo matter, which is the Constitutional Court, where they describe the local government as a hybrid system. So it's not the same. The court found that it's not the same system as how we understand the executive authority, for instance, of the ministers or of the president in government. It's a hybrid system that's sort of the municipality has its own executive authority, but it's still subject to national legislation. So we just refer to that case as an explanation as to how the executive authority of the municipality must be interpreted. And then also section 164 of the Constitution states that any matter concerning local government not dealt with in the Constitution may be prescribed by national legislation. And as we know, there is no provision in the Constitution that specifically provides for a procedure, for instance, on how a municipal council can appoint employees or which sort of requirements that appointment must comply with. So many of the authors and some of the cases that we refer to in my opinion, basically states that those matters that are not dealt with in the Constitution may be prescribed by national legislation, and hence the municipal systems may very well prescribe that procedure for the appointment of the municipal manager or then the manager directly accountable to the municipal manager in the Act. So that will not be seen as unconstitutional, because it is a manner of prescribing to the municipal council how these managers must be appointed. Another case we also referred to was the Executive Council of the Western Cape case. That was on page 30. We discussed that case, where the obligation on a municipality to appoint a municipal manager was alleged to be unconstitutional. And also for the same reason that it was alleged that it violates the municipality's right to regulate its internal affairs. But the Constitutional Court then dismissed that allegation and held that the municipal manager is a key structure of a municipality and not merely a personnel appointment as contemplated in Section 161D of the Constitution. It is thus permissible for national government to make provision for the appointment of the municipal manager in terms of Section 1557 of the Constitution, which also authorizes the national government to enact legislation to regulate the exercise by municipalities of their executive authority. So in conclusion then, Chairperson, we basically said that it is not unconstitutional for the Municipal Systems Act to prescribe to municipal councils how they must appoint managers, and managers directly accountable to them. And we also found it not to be unconstitutional for there to be a differentiation between the municipal manager, and the manager directly accountable to that manager. Thanks, Chair.
Thank you so much, Yolanda. Before I've seen what the department has submitted. It's in relation to the case study from the Western Cape that we want you to talk on about. There was also a research by the Institute of Local Government. There is also a PDG research study by the department. And then also then there's evidence that has been presented. You'll tell us by who that shows that the fixed contracts are vulnerable to abuse. And then, yes, at the same time, no thoughts given on the possibility that permanent contracts can be abused. This is before I give Salga. So those are the issues, because remember the last time we said, share with us your consultation, in particular to this clause that MM's managers accountable to MM must be made permanent. We raise it coming from, and I'm glad that the state law advisor now is advised to say it will stand a constitutional challenge. There's nothing wrong by that. We are fine. But then we need to also say that, because during our engagement, these matters, when they come, the department said that there was consultation. So then wanted to understand the extent of the consultation, because so far that I've seen is the 3. And the worst one, with the one done by the PDG research, it concludes that there's nothing wrong with fixed term appointments, but the research doesn't shed the light on permanent appointment of a Section 57 manager accountable to the MM. It was only talking to the MM. So the issue here, we must remember, we're dealing with managers accountable to the MM. So it's up to you, to the department. You've sent us a list. So I think you need to talk to each of the submissions that you sent to us now. Over to you, the department.
Good evening, Chairperson, and good evening to all the honourable members. I'm accompanied by the management in the department, and Tebogo Matla Shuping will be leading us and sharing with us the outcomes of the consultation process, Chair. Thank you.
Yes. Are we ready?
Thank you, Chairperson.
Was
I-
there a presentation prepared apart from the documents sent raw as they are to us to summarize each?
Chairperson, there was no presentation presented because we were of the opinion that we presented to the portfolio committee in the past, and then we submitted the work that we have been requested to do in terms of us coming with any other study that indicated where this particular proposal that you are coming with works. So our intention was to talk to the 3-4 documents that we submitted to the portfolio committee, and stressing in particular where we are highlighting success stories in relation to our proposal. But the essence of our talking to the presentation will be based on the work that we were given by the portfolio committee when we presented the last time.
It should be not only success stories based on what we said. So it may only selected those that deal with success. The ones that were not sharing the success stories, you need to share with us, because we wanted to understand the consultation, the extent of them. That's why I only zoomed the 4 that I could see thus far. Then but proceed, the 10 is yours. Then you'll tell us which one are you dealing with, and then you need to express an opinion on those as we proceed. So for the benefit of the members, you tell us now if you are dealing with the LGM proposal, let us know, so that the members can browse that, because there's no presentation done to that effect.
Thank you, Chairperson. Chairperson, I will start first with the issue relating to the consultation process that we embarked on the bill, and the consultation that we conducted. We submitted a list of institutions and organizations that we consulted when we first introduced the bill. You recall that this bill is resubmitted to Parliament as is, as it was in the bill that was then dealt with in 2010-2011. So when we look at the package that we sent to the portfolio committee, there is a big, some sort of a template that we completed, indicating all the other stakeholders that were consulted and their views, and how we interacted with them, and also in relation to whether we agreed with their proposals or not. And that is contained in that page that is about 130 something pages, the document that is 137 pages. Maybe honorable members might not have that thick document, but it was also sent to the portfolio committee, because it has all the issues that were raised and issues relating to the interaction with our good selves. It is also so that before this was introduced to cabinet recently, until it was sent to the portfolio committee, that the discussion was held with the portfolio committee, and we've got minutes of the MINMEC actually, that we had discussions with MINMEC in relation to the reintroduction of this bill with the same provisions that we had when we introduced the bill. So in compliance with the court order, the constitutional court order, we then resubmitted as is. Rufus has got the dates of the different technical MINMECs that we had, where I presented the bill to the technical MINMEC and also subsequently to the political MINMEC. And we've got also the minutes of those minutes wherein MECs and also HODs of provincial department discussed the bill itself. Now, coming to specifics in relation to the our proposal of taking or having managers accountable to municipal managers on a permanent basis. We have looked at cases in the Western Cape because Western Cape was KZN and Northern Cape were the leading municipalities in relation to having appointed municipal senior managers accountable to municipal managers on a permanent basis. So I'll start with the Western Cape. With regard to Western Cape, there are municipalities, but before coming to municipalities, there has been some sort of a motivation that relates to why the national and provincial departments were of the opinion that managers accountable to senior managers should be on a permanent basis. And that is in addition to the two presentations that we made earlier on. In relation to municipalities in the north in the Western Cape, firstly, it was in relation to the security of tenure, that in instances where senior managers are not appointed on a permanent basis because of insecurity, that created some sort of a lapse in relation to them performing to the optimum level, because knowing that they will only be in employ of a municipality for a period of between 3 to 5 years, depending on when they were appointed. And because of that lack of security, there was an instance where senior managers will not give in their go because of the fact that they know that upon the expiry of their term, then they'll be out of the system. The second one was in relation to the institutional stability and memory. We have already indicated, and I've said it in our presentation in the past, that the retention of highly experienced managers has a problem in relation to when they are to be reappointed. But in instances where they're appointed on a permanent basis, that retains the skill and also the investment that we made in capacitating those senior managers. The third one was in relation to succession planning that we also iterated, that in the Western Cape, those municipalities that appointed municipal managers on a permanent basis then had to have a succession plan that also gave some sort of certainty to managers accountable to senior managers. The fourth one was that of building a stronger management team that over a period, and will demonstrate when we look at one by one municipalities instances where they have been appointed on a permanent. I'm not going to get too much into that, but it's safe to say that when you look at the document that I'm referring to, there is point 5.1. 5.1, there is a table that indicates those municipalities that have appointed managers on a permanent basis. One being Swartland, the second one being Bergrivier, Mossel Bay, Esekwa, and Cape Agalas. And when you look at the level of governance where they've appointed managers on a permanent basis, you look at how they are faring in terms of the ratings in the Good Governance Africa, a reputable institution that grades municipalities in relation to their performance. And when you look at the audit outcomes, because of this appointments of senior managers, you realize that they have unqualified audit outcomes for the years that are indicated on the template. And Swartland had unqualified since 2018-19 and unqualified with findings. And from 2016-17, 2017-18, there has been an unqualified report, including Bergvlei, including Mossel Bay, Esekwa, and Cape Agalas. And when you look at their compliance with legislation, because of that certainty in relation to retaining those skilled senior managers, there has been no findings in relation to compliance. When you look at irregular expenditure as the result of the audit outcome, it also indicates the decline over years in relation to the irregular expenditure, because of the fact that we've got these managers who are from time to time being able to give support to councillors and also to municipal managers. MIG, there's been between 95% to 100% expenditure on MIG in instances where we retain them over a period on a permanent basis. The turnover of senior managers in Swartland, none, they're all there. In Bergrivier, it was 2 positions only. With regard to Mossel Bay and the others, 1, and Cape Agalas, there was no turnover, meaning that the retention of skills were there. That is why there was a consistent attainment of positive audit outcomes, because these senior managers who are already in the system will then build on the previous year's findings, and that continues over years because they're permanent, especially in relation and also matters relating to the clean governance. You'll see that in instances like Berkeley, where there were allegations of misconduct or allegation of criminality and corruption, there has been an action and consequence management that were taking place. With regard to the rest of municipalities, there were no allegations of corruption, because, as we'll see when we go further, the issue that we said vulnerability in relation to that is that in instances when you have them on a fixed term contract, they are prone to corruption, because they know that within a period of 3 to 5 years they'll be out. But once they are appointed on a permanent basis, they fortify, also they work harder in achieving the possible audit, positive audit outcomes, and also cases of where there are no allegations of misconduct. We also looked at 5.2 instances where senior managers accountable to municipal managers were appointed on a fixed term contract in the Western Cape now, in this particular instance. And you look at Cederberg, you look at Old Warren, and you look at Beaufort West. These are the ones we sampled. And when you look at them on 5.2, when you look at the findings from 2016 to 2019, for Cederberg, it has been unqualified with no findings. It was unqualified the following year with findings, and 2018-19 was unqualified with findings. Old Warren, which was also characterized with some sort of challenges, 2017 was qualified, 2018 qualified with findings, and unqualified with findings. So this, we are showing the balance that, like the chairperson has indicated, we're showing instances how they fared, even in instances where they've appointed managers on a fixed term contract. And there goes down in other issues relating to compliance with legislation, irregular expenditure. When you look at the regular expenditure, you look at the high level of the regular expenditure from 61.5 million to 170 million on an annual basis. Now, this indicates they are also performing well, these three municipalities, in relation to fixed expenditure. Disciplinary cases, there were 2 in Cederberg, one in Old Warren, and none in Beaufort West. And there goes in relation to the turnover of managers. We look at also the method of. In conclusion, in relation to Western Cape, we are indicating that one of the most successful and one of the best municipalities in the country, which is Municipal, has got all senior managers appointed on a permanent basis. The second one is we then approached the Institute of Local Government of South Africa. This is the institution of representing senior managers in municipalities. Senior managers include,
otherwise we are going to miss issues. Ne? I'll prefer you raise one, we ask questions for clarity, then you go to the other one like that. Otherwise we are going to lose the track of this. I think let's do that, colleagues. Colleagues, here's the presentation on the Western Cape submission. What is your take on that? You fine with that, Kleza? I see you're here on the screen.
I am. Chair, thank you very much. I am really, I am still in lackadaisic in terms of what is the proposal of the municipal managers that are accountable to the municipal manager. being permanent
Yes.
going to give rise to consequences that are desired by municipalities? Chair,
You know what, Honorable Teza? I was
yes, yes.
thinking if the clarity issue seeking with regard to the Western Cape a submission on this issue. Overall, other issues, I think at the end, you're still gonna come back to raise the issues like you're saying. Or should we allow it? Maybe, yeah, I think the way you're doing it so that let me maybe just allow him to finish all of them. Just note your issues. Then you tell me you are talking to the Western Cape submission, you are talking to the ILGM submission, you are talking to the PDGM submission.
I'm talking to the first submission, chair, that we've had.
The Western Cape one.
The first one, we had
the one by Yolande, eh?
Yes. I
Okay.
wanted to ask.
Okay, let's deal with the state law advisor one. But I think then it also me causing the confusion. Let me apologize. So that we holistically maybe deal with all of them. Because already Yolanda has done that for state law advisor.
Yes.
He has presented the view of the Western Cape. Can we allow him to deal with the others and allow Salga? So that then at the end of the day, then I just then plead with you colleagues, you must be focused, ne? So that you listen to all of them and then we'll come at the end to ask all the presentation. We'll have to deal with the state law advisor presentation, deal with the department's presentation, and then deal with Salga. Then we can ask questions. Then just be patient. Then let you allow you have done with the Western Cape. Come to the next one, Debo. My apologies. I thought it's gonna make matters easier, but I realize it can create problems. My apologies, Debo.
Chair. Chairperson.
Yes.
Ngiyacela nje ubaba uTebogo mhlamba angakhulumi asheshise. I know ukuthi mhlamba is the way he talks, but if nje kancane because we are trying to get what he's saying.
Okay, he mustn't be so fast the way he's doing it.
Yes.
You are trying to digest also the sense of the things that he's saying. It's okay. Okay. So it's fine. Okay, sure. Let's proceed. Ebo, you've disposed the Western Cape one. Go to the next. ILGM, please. DG.
Thank you. Chairperson, you say I must proceed with the next one.
The other ones, you tell us which one are you dealing with now?
I will deal with the ILGM one. First to say that the ILGM is the institute that comprises of senior managers in municipalities, and that also include middle managers in municipalities. And their experience also is of importance in trying to indicate to us how municipalities in the 3 provinces that they've got membership on have fared when they've been appointed on a permanent basis. I will speak slowly. I thought I had to speak fast for the interest of time, and I apologize for maybe having confused honorable members. The report that relates to ILGM, when you look at their experience in Western Cape, they are also citing the very same municipalities that were cited by the Provincial Department of Western Cape, and also as in determining in looking at how they fared, where they've appointed senior managers on a permanent basis. And that relates to West Coast, Overstrand, and all those municipalities having received clean audits. And also relating to when you look at Western Cape, in instances where you have the high turnover of municipal managers after each and every 5 years, and even within the 5-year period, they also are alluding to those municipalities that are even not doing well, like Kanaland, Langsberg, Bitoy, Beaufort West, where there was a high turnover. And that also is the issue that has been raised by the AG, that these municipalities are not doing well in terms of the audit outcomes and also in relation to good governance. And they are now also relating to KwaZulu-Natal, where they have appointed, where municipalities have been appointed on a permanent basis. And that includes Gungundlovu, Usunduzi, Kwadukuza, and it shows also issues relating to stability in those municipalities, and Musunduzi having a problem of influence from outside the municipal space that led to instability. But as you are aware, after the intervention of the national and provincial department at Msunduzi, at one stage, there was stability. And at the time when they appointed the senior managers on a permanent basis, there was stability. But there were other factors outside the municipal space that made Msunduzi not to be stable. When you look at eThekwini, they've got 2 out of 8 senior managers who are appointed on a permanent basis, and they've got a CFO who is appointed on a permanent basis for over years. And it also manifests itself in the outcome, the audit outcome of eThekwini in relation to it receiving a clean audit. And that is as a result of the CFO who has been there for over years. So we are, the ILGM is also building a strong case in relation to issues of where there has been an appointment of senior managers on a permanent basis. That also make reference to Cape Town, that has one of the healthy, positive audit outcome as a result of this step that has been taken by the municipality. I must also indicate that we are all aware that the CFO of Thekwini has been there for approximately 25 years over a period of certain positions and all that. And they have, as a result of that stability in terms of their audit outcomes, they have been receiving a very good audit outcome. In relation to Northern Cape, there is Namakoi and Karahais that has got all permanent senior managers, and they have been performing well over years in terms of the audit outcomes. And that shows also that a particular trajectory then transpired once municipalities this in the Northern Cape decided to appoint as senior managers on a permanent basis. That relates to also the quality of service delivery. Even now, it is not up to 100% standard, but in instances where appointments has been made, there has been a positive outcome, and also quality service delivery that has been exercised in those municipalities. And the ILGM has also indicated in relation to their benchmarking overseas that most of the successful municipalities overseas have appointments of their managers accountable to to municipal managers on a permanent basis, and that is in the US, in the UK, and Australia. And they even look at the trend where even in actual fact in those countries, senior managers are appointed by city managers, or what they are being termed as chief executive officers, who are appointed on a fixed term contract, and those managers accountable to them, they are appointed by the city manager or the chief executive officer on a permanent basis. And that's a difference in relation to us. And they also have a study that the sample of the legislation in Australia that indicates how this particular phenomenon is exercised in Australia. So those are the case studies that we have that indicated how the permanency of senior managers accountable to municipal managers will assist municipalities to be stable and to perform optimally. There is also a case study that was conducted by Cooperative prior to the promulgation of this act that was done by that institution. And in that chairperson, you realize that it is just not looking at various municipalities, but overall, making a case that we made at the time when we first introduced the bill to Parliament, that where there is certainty in relation to senior managers accountable to municipal managers, there has been some pockets of excellence, and there has been less corruption-related cases as a result of officials having been sure that their appointment will do over a longer period, and that they can invest more in the kind of work that they are doing for the advancement of those municipalities. And that particular report also assisted us in coming to a conclusion when we, as Yolanda has already referred to, when we moved for the removal of Section 377 in relation to other permanent or on a fixed term contract for senior managers. It was really based on that particular study that supported our proposal at the time. We also had a discussion with NETLEC at the time, and NETLEC also looked into this, and NETLEC agreed with the proposals that we had in as far as it related to us having a constant senior managers being in municipalities. And we are also indicating to the portfolio committee that this process is now a parliamentary process. We are only indicating what we are indicating now as requested by the portfolio committee to just support our proposal in relation to this particular clause that requests that senior managers accountable to municipal managers should be permanent. But if maybe the portfolio committee or parliament is not convinced in relation to our motivation, and then the portfolio committee might take a decision that is best to the best interest of local government in this instance. I think I'll pause there, Chairperson, and I will then, together with the team from Cooperative, respond to questions that may be asked in relation to the case studies that we have cited here.
Will come. That time will definitely come. Can I hand over to Sarga? Sarga, is it Lance who's doing that? Councillor Stefile, are you gonna doing the presentation?
It's Lance. Yeah.
Now I understand the reason why he complains. I'm overworking him. Lance?
Chairperson, good evening, Chairperson,
Yes.
and also members of the committee, the deputy ministers, DG of Cooperative, and colleagues who are present. Chair, I have never complained to work. There's one thing you should know. I don't complain working. In fact, I enjoy it. It helps me. But when it comes to presentation, Chairperson, that has been requested of Chair, I'm hoping I'm audible. I am in the darkness here. We are sharing, so I hope that my audio is sustained throughout. There are a few areas, Chair, we would want to remind the committee on that we have previously raised with the committee based on our previous submissions, is that we had said that, and we have made this point consistently from day one, that it is our view that there should be a comprehensive review of the Systems Act. We strongly feel that the manner in which we are dealing with the Act itself is trying to introduce stopgap measures, when in fact there are many other issues that we need to review, taking into account the experiences of the last 19 plus years of democratic local government, going for 20 years. So we have made that point, but we unfortunately hear that we are focusing on key aspects introduced by the 2011 Amendment Act, and we have not gone beyond that. And we would also expose today where we think there are areas that we are still not considering, but yet there's a link with the conversation that is taking place during this deliberations on the amendment bill. Secondly, we have raised issues around what is interpreted as concurrency by MECs, meaning there is an expectation that MECs are to approve the appointments concur with the appointments, whereas the legislation is quite clear what the expected role of MECs are. There's also been questions around interpretation challenges, and they've come out clear this evening as well, based on the opinion presented by the state law advisors, and we will touch on that in a slide or two that is to come. We have raised the issues of limitation of political rights. We've made an extensive presentation on that, and we've also raised concerns around the continued validity of regulations, but we have come to an agreement with COPTA. We were quite comfortable with that agreement to introduce stability within the sector as we speak. So out of all of these areas, Chair, what remains on the radar screen is this third bullet point, the interpretation around if the employment contracts for managers directly accountable to municipal managers should be for a fixed term period or for a permanent basis. And we will focus largely on this in our input. Now, we have previously said to the committee, and we're not going to remind the committee, these are the current provisions in the Systems Act that are under discussion. The subsections 6 and 7 of Section 57 of the original Principal Act, and now the proposal for the deletion of 57.7 of the Act. So what we have raised as practical challenges, which will become clearer, Chair, in our following presentation, is this issue of, when we came to the committee on the 25th of February this year, we said our concerns, looking at the practical challenges, is that there are certainly differing approaches being taken by municipalities on the appointment of senior managers. Some municipalities are electing to appoint on a fixed term basis. Some municipalities are electing to appoint on a permanent basis. There is an interpretation and a view expressed by COPTA. There's an interpretation and a view expressed by SALGA itself. And today we will also received the state law advisor's opinion on that. And we have been quite concerned about this development. And in our view, and we've been saying this, and we will indicate we are not the only ones who hold this view, that in our view, there is still a discretion to a municipality to determine the terms of employment of managers directly accounted to municipal managers. And as such, municipalities can appoint on a fixed term basis or on a permanent basis. That has been the SALGA view on the matter, Chair. We have heard from COPTA, we're not going to repeat, but we just want to paint the full picture. We have heard from COPTA in the last committee discussions on the bill on what COPTA's views are, what will be introduced by having permanent employment. So these are some of the negative areas that COPTA has raised that finds expression within the local government space when people are on a fixed appointed on a fixed term contract. And COPTA has recommended, as they did previously and do so today, that these are the positive things that we are going to see. And we're not going to repeat these things. COPTA has spoken on length on this. But what we have done, Chairperson, we thought as Salga, we will go to our members and test this thinking with our members through a quick survey that we've conducted. So after the last meeting, we went back to our municipalities, all of them, and we said to them, can you assist us with information? Because we want to test these views that are being raised based on what finds expression within local government itself. So we did the survey, and what we wanted to do is to assess a number of things. How many senior managers are appointed on a permanent basis as we speak in July 2020? Not far long ago, as we speak in July 2020. How many managers are appointed on a permanent basis? How many are appointed on a fixed term basis? Where they are appointed on a fixed term basis, for what term of period are they appointed? What has been, comparatively speaking, the recent municipal audit outcomes as announced by the AG on the 1st of July for municipalities with permanent senior managers and municipalities with fixed term contracts? We've taken it a step further. We've also asked, comparatively analyzing the Section 139s since 2011. And the reason why we use 2011, Chair, is because the Amendment Act of 2011 came into effect then, and it is then that municipalities started appointing people on on a permanent basis in the main, but because continuously there has been the fixed term contract. So we tested since the appointment of permanent senior managers from 2011, which municipalities have, comparatively speaking, appointed senior managers and or fixed term, and what has been their status in terms of Section 139 interventions. So we went the survey and we got feedback, Chairperson, from 95% of the municipalities. And this is the picture that it comes out of that survey. And all we are throwing to you, Chairperson, is what the survey is telling us. And here is the picture that is presented, and we have the detail. We can give the detail, and the detail, what it does, it breaks down for each of the provinces and in each of the municipalities, how many people are appointed on a permanent basis, how many are appointed on a fixed term basis, and for what period are they appointed, where they're appointed on a fixed term basis. Also, what has been the audit outcomes and what has been the Section 139 status over the last 9 years. But if we compare permanent versus fixed term contracts, you will see across the provinces, there are 4 provinces, Free State, Limpopo, Mpumalanga, and Northwest, that have not appointed any permanent senior managers. So in 4 provinces, no permanent senior managers. But you will find on the remaining 5 provinces, there are some senior managers that have been appointed. And the numbers that appear there are the number of senior managers appointed. Then you would also see the number of fixed term employees at the senior management level. And then the last column shows you the total. Now, if you look at this picture, Chair, the first point we want to make is that these appointments that have been made, all of these appointments that have been made, would have been made by a municipal council, firstly, and secondly, there would have been a communique by the municipal council to an MEC to say, these are the appointments that we have made as prescribed by the law. These are the appointments that we have made. We are communicating to you to assess whether the processes have been duly followed. So for all of these appointments, MECs would have assessed the appointment, and where there were problems, they would have raised concerns. So when I say SALGA is not the only ones that held the view that senior managers may be appointed on either permanent or a fixed term basis, you can certainly see MECs that did not find any problems with these 890 appointments in these municipalities held the same view as SALGA. So if you want to go to the Western Cape as an example, because it's consistently used as an example, if you look at the picture here, it's almost half, almost 50% senior manager permanent, 50% on a fixed term basis. So here you certainly have an MEC that would have interpreted the Systems Act the same way that SALGA is interpreted, because that MEC would have, in inverted commas, concurred with these appointments that have been made. That's the first point we want to make. It's not a SALGA interpretation. You can certainly see across the provinces there has also been the interpretation of MECs in the provinces, because if it was not that interpretation, they would have raised issue with all of these 809 appointments made of senior managers on a fixed term basis. But the second point I want to make, Chair, is this picture here of 84%. So you certainly see that there's an overwhelming preference by municipalities to appoint senior managers on a fixed term basis. And that is the picture that is painted based on the survey that we've conducted. Secondly, Chair, on the audit outcomes. So what we have merely done in this slide, we are similarly taking the approach of a provincial picture. We have taken the 6 types of audit outcomes as determined by the AG for the last 2018-19 financial year. So clean, unqualified, qualified, adverse, disclaimer, outstanding. So for municipalities that have appointed permanent staff, senior managers, you will see in the Western Cape, 7 have obtained clean audits. You will see across the provinces that have senior managers, 22 municipalities have attained unqualified. But you must also look at the flip side. So this is the positive side, Chairperson. The 7 and 22 is the positive side. But let's also see on the flip side. So you have 4 municipalities that have permanent employees with disclaimers. And you have 2 municipalities with permanent employees with outstanding audits. We'll pause there on this slide, Chair. But what it tells you is that there are 2 sides of the coin when you deal with permanently appointed senior managers. Similarly, we have done the same exercise for fixed term contracts. We're not taking a position, we're just saying this is what the survey is telling us. It says to us, across the provinces, there are 14 municipalities that have appointed fixed term contract senior managers, and they have obtained clean audits. 75 of them also unqualified. That is the positive side. But we also have the negative side here. 25 disclaimers with fixed term contracts, 21 outstanding audits with fixed term contracts. Again, 2 sides of the coin. There is positive and there is negative. So we bring the 2 together, Chair, so that you can see the picture on a single slide. So we present to you the picture of permanent employees and the related audit outcomes versus the picture of fixed term contracts and audit outcomes. And here you can see if you compare it total, there's a higher number of fixed term positive results. There's a higher number on clean audits. There's a higher number on unqualified, but it could be informed by the number of municipalities that have preferred fixed term contracts. But you also see the flip side, that there's an overwhelming number of municipalities with negative audit outcomes where there is fixed term contracts, but there's also certainly not a convincing picture that says if you are permanently employed, there is a consequent improvement in your audit outcomes, because yes, this is what the picture is telling us. So that is the picture, fixed term versus permanent. and the related audit. On Section 139 interventions, Chair, a very similar picture across the provinces. For municipalities that have appointed permanent employees, there are examples, 2 of them in the KZN and 2 of them in the Western Cape. So 4 municipalities with permanent employees have been subjected to 139s. But also, there are 95 municipalities across all of the provinces with fixed-term contracts that have also been subjected to Section 139. What we're trying to say to you, Chair, is that certainly you see both sides of the coin. So there is no guarantees. Essentially, there is no guarantee that you are not going to have a good audit outcome. You are not going to have you're going to have a good audit outcome, or you're going to not be subjected to 139 if you have permanent employees. And this is the picture that is being presented to us through the survey. So not something that we have thumbs up. It is what is coming from based on the information to present it. So in summary, Chair, what the survey confirms certainly to us is that an overwhelming number of municipalities still prefer the fixed-term contracts and continue to appoint people on a fixed-term basis vis-a-vis the permanent appointments. We also want to advance a view based on the outcomes of the survey is that permanent and secure clean audits. But so too we can't similarly confirm the same for fixed term contracts. So we can't convincingly say that either or is better. Thirdly, we're also saying that as much as municipalities with fixed term senior managers have obtained disclaimers, we have also presented through the results that municipalities with permanent senior managers also have disclaimers. And the same point could be made for Section 139 interventions. With fixed term senior managers, there are Section 139 interventions, but also for permanent senior managers, there are Section 139 interventions. So the overwhelming, the main point we want to make, Chair, we can't reach a conclusion, certainly not based on the data that came out through this survey, that municipalities are more stable or they perform better if senior managers are permanently appointed. If you look at your metros, Chair, and this thing came out last week, Thursday, in a meeting of the National Executive Committee. All of our metros, it is only Buffalo City that has all of its senior managers appointed on a permanent basis. Of all of the metros, let me repeat, Chair, of all of the metros, it is only Buffalo City that has the entire senior management, excluding the city manager, appointed on a permanent basis. And the mayor of Buffalo City stood up in the meeting and he said, there is no benefit, certainly from their own experience, there is no direct benefit that things will improve with permanent people. While certainly that has not been his experience in his time as the mayor, now serving his second term there in that municipality. He's certainly not saying that, confirming that them being the only ones with permanent senior managers, that there's been positive spin-offs because of the appointment of the managers on a permanent basis. The second last slide, Chair, before I conclude, we want to make this point linked to the earlier point that we have made around there is a need for an overhaul of the Systems Act, and it is linked to this slide that we have presented earlier, but we want to highlight 2 areas. So for municipal managers, we are, based on the current argument from COCTA, we are saying that municipal managers must continue to have fixed-term employment contracts, and their employment contracts must be linked to a year of the term of office of the council that appointed them. So the question we want to ask, what informs this thinking? So if there's a different thinking for senior managers, what informs the thinking that for municipal managers, this limitation must still apply? So we are saying there is a need for us to ask this question. If we want to breathe life into professionalizing local government, why are we then not say the entire staff complement? Why are we then still retaining? What are the reasons that we are advancing to say no, a municipal manager is the exception? He must be linked to the term of office of a council. Do those same reasons not apply to senior managers as it currently does? The same reasons that people advance. So we are saying we are talking about senior managers, but we are leaving behind the municipal managers. So why are we still retaining that argument for municipal managers if there's a broader argument around professionalization? And that's the point what we are saying, Chair. There is a need for us to really look into, because we are dealing with things piecemeal. We need to look holistically at the systems act and overhaul it in its entirety, and do that once and for all, and not do it in bits and pieces and leave others behind. So what we would want to recommend, Chair, is the last slide, just to note the recent survey that, but we would also want the committee to give serious consideration to our supplementary submission, which we would want to propose that, in our view, the discretion that is currently applying to councils to appoint senior managers on either a fixed term or a permanent basis should be retained. So the current experience should be retained. We certainly do not think that we are ready. The system is not ready for permanent employment of staff. There is a lot of work that needs to be done. We are not there yet. Secondly, we would want to, in addition, propose that if that discretion remains, that we must ensure and provide that MSCs continue to appoint, to monitor the appointment in line with the legislative framework, so that MECs can say, when municipalities are applying that discretion, what informs the application of that discretion as part of them monitoring the appointment of senior managers. And lastly, we think that it is time, Chairperson, we have made attempts, but we have not dealt with it holistically. It is time for a rigorous performance management system to be introduced, where performance of municipal staff starting at the senior management level are properly assessed, and that appropriate correction action is taken where it is necessary, so that we can get rid of the bad apples that we do find within the local government's place. And then lastly, Chairperson, in line with our earlier proposal, we think there must be urgent work commissioned to totally overhaul the Systems Act instead of dealing with things piecemeal as we are currently doing, Chairperson. That's our presentation, Chair. Thank you very much.
Okay. Thank you so much, Lance. Colleagues, so we have all the three presentations. Can we engage on them? I believe Councillor Stofile, you'll be able to also assist in providing the responses if members will have questions. And as you do that, then I'll give you an opportunity to say any other things if through the questioning you feel that there were matters that were not adequately attended to. Colleagues, can I see a show of hands who wants to interact with this presentation? Leza, you were the first one. I noted you, Honorable Leza. Then Inkosi Lutuli.
Chair. Thank you.
Yes.
The fact that Chair.
Wait, Kaiser.
And
Yes,
Hussein also.
Hussein as well.
Mkalipi,
Brink, please.
Mkalipi, Direko, and Brink.
Hadebe with H.
And Hadebe with H. So it's the 7 of you. Did I miss somebody's Kaiser? Lutuli, Hussein, Mkalipi, Direko, Brink, and Hadebe. In that order.
And Groenewald, Chairperson.
And Groenewald. Groenewald. Who else is it? Kevin. So, yes. Kaiser?
Thank you, Chair.
Sure.
It's on.
Yes.
Thank you. Thank you, Chair. It's, you know, if you look at Salka's presentation, I don't know what that page is. It's fixed terms contract, audit outcomes, number of municipality. You according to that survey, Chair, you are surely to see that there is no guarantee that that it looks like people when they get permanent work they relax there according to that survey there. It looks like really everyone is relaxing all the way to 9% there. So it just covers me in terms of whether there is a guarantee or not of people. Even though we are of the view that people must find good working conditions at work and be employed under good circumstances. But what I'm thinking, where I'm coming from, Chair, is that perhaps what Salka covers in terms of performance, the monitoring of performance, you know, tighten the monitoring of the performance rather, because according to that survey, really, because it does not look like we are getting to a space where we are really not creating more problems for municipalities. As my colleagues have said before, that the unintended consequences that could be caused by a municipal manager who is not considered to be permanent, when his junior is actually permanent, we will bring about challenges in the municipal space, and the more the challenges within the leadership, the more it impacts on the services that our people are waiting for on the ground there. So in that sense, according to that survey, I think that SARCA then covers me in terms of that, even though we are of the view that really in terms of the conditions of the Employment Act, they must apply all the time, consistently with anyone in South Africa that is working, regardless of whether he's a municipal manager that is accountable to the municipal manager or not. Thank you very much, Chair.
Thank you, Honorable Kaiser. Honorable Lutuli.
Thank you very much, Chair. We have the last one. I can say the last one to me as a SALCA. Really, SALCA in my shoes. I can say that I'm with them because the way they analyze this what we're talking about, it's very clear that Salka knows exactly what they are doing. Because that I was querying it before, just because of it's just because of if the manager, it managers under the municipality manager, they are permanent. Knowing that a person whose job is to look after the people will be permanent, but at the same time, those people, the very same person, he will take the job as his home, not on job. Really, I would not like to expand more because they covered me, showing that we were opposing this because it will create a problem, and then at last that will be the job of the chairman of that time, because we'll never know. Next year we won't be here. 2024 sometimes we will be not be here, but we must have a stepping stone so that things will go right from on our time. We must make it this thing look right till the end, because really I was not comfortable really. Okay, to me, I was not comfortable at all. But now I will say that I'm comfortable about the proposal of the SALCA, because SALCA is the one who's dealing with those people, or who's dealing with the municipalities. The municipality affiliated under them, they got a lot of job to be done. At this present moment, I think they are making even their job will be easier from today onwards. Thank you very much, Chair.
Okay. The next speaker is Honorable Hussein. Thank you, Ndabezit. Honorable Hussein.
Chair, thank you. If you don't mind, I'm not going to use the camera. May I just say, Chair, I think, and I want to just express my appreciation for that study that Salga had done. I think, I mean, you know, I keep singing the praise of Salga, especially when it comes to the quality of the documents and the research and the effort that they put into it. So, Lance, thank you very much. I know I was teasing you earlier about the work that you do, but really the quality of that study, I think, is really very, very good. And thank you very much. I would like to use that to spend a little bit more time giving some thought to it. But I do think, Chairperson, that perhaps some of those key result areas that Salga had looked into need to be expanded. I don't think that it should be limited to only those areas that they have looked into in respect of audit outcomes and so on. I think that there might be other factors that they want to take into consideration. I mean, the reasons that COCTA had advanced in terms of stability, in a number of areas, I think we need to perhaps maybe look deeper into that as well. I remain convinced, Chairperson, that the permanent appointments are a good thing for municipalities. But let me also at the same time be open with my colleagues on the portfolio committee. And I'll speak to you like a politician to another politician. The bottom line is, Chairperson, as an opposition party, having senior staff on fixed term contracts suits us. I'll be honest with you. It suits us as a political party for very obvious reasons you can work out. But the question I ask myself is that, does it suit the broader interest of our municipalities when it comes to service delivery? The answer to that is no. So if I have to put the interest of my political party first, I'll say, let's go with a fixed term contract. But if I have to put the interest of the municipality and our country first, I'll say, no, it's the right thing to do is to have permanent appointments. Because some of us come from municipalities for a long time, and we've seen how things have changed between when you have a very stable senior management structure in a municipality and how things change how it's changed over a period of time on these fixed term contracts. For the reasons that Copter has already advanced, I don't want to go into it and repeat it again. I'll give you a very real case scenario, Chair. And the last comment, I think, from Copter about the levels of corruption is extremely relevant. And I mean, this is an important part, and all of us must give a lot of thought to it, because it has massive implications for municipalities across the country. But imagine somebody is employed for a period on a fixed term contract of 3 years. And in the last year, he knows he's not going to be there for a very long time. The propensity for corruption is much greater in that circumstance, because that man knows that he's not going to have a job very soon. So he best do whatever he can to try and put as much money as he can in his pocket, because he's not going to have a job for the next year thereafter. So it actually becomes an incentive for corruption, if you think about it. And there are many other reasons. What I just find a little bit strange in that I would have thought that Copter and Salga would have come through to us on a combined position on this one, but clearly they're taking two different opposite views, and that's okay. But I do think that there needs to be a little bit more in-depth consideration about that proposal. If we want to act in the best interest of our municipalities, Chairperson, I remain on the view that the fixed term contracts, again, is good for us as opposition parties, and you can support it. But it's not good for municipalities on the long run. I think maybe just leave it there, Chair. That's the only comment I wanted to make. I think the point around the question that was raised previously about the constitutionality of the proposal, I think we can put that to bed now. It's very clear that it is possible, that there isn't any constitutional challenges. What's really left, Chairperson, is the politics around it, I think. And at some point, we must just have an open conversation about where we stand on these things so that we know what the direction is going to be and see if we can find each other on it. But thank you very much.
Okay. Thank you, Honorable Wilson. Honorable Mkalipi.
Okay, Chairperson. Nami, can I please switch off my video, Chair? The network is not good in Durban.
Okay.
Yeah, Chairperson, I just want to also to concur with my colleague, Honorable Hussein, on the points that he just made. Exactly, thanks from Salga. They always excel when it comes to presentation. They just simplify things for us. And I also want to agree with Salga when they say that instead of looking at this amendment in a piecemeal, maybe it's an opportunity for us to look at broadly or holistically. As far as I remember, Chair, we are no longer trying to address what the Constitutional Court said. There's no date now. Maybe it's our opportunity just to look at this amendment with a different perspective. But the fact of the matter is that we as the FF, our standpoint is very clear. We want people to have permanent jobs. And it must be very clear, Chair, that we must not punish our workers on the basis of what is happening on the municipalities, especially the dysfunctionality of the municipalities is not squarely because of the workers. Having said that, Chairperson, I should think that the dysfunctionality of municipalities comprises of many things, which sometimes is beyond workers, is beyond the staff members of each municipality. And we have been saying this here, as Comrade Hussein was saying, sometimes we have to talk as politicians if we want to go and make sure that what is wrong in the municipality must be fixed, and we must talk honestly. I know that one of the aspects that we want to achieve, all of us, at a municipality level, at SALCA level, at department level, is to see the municipalities functioning very well. And the only thing that we have as a weapon is staff workers, is workers on those municipalities. But as long as the element of corruption is not confronted, that one will always contribute to the dysfunctionality of the municipalities. And it needs also a political will of politicians to deal with such. I know very well that our angle here is, as portfolio committees, as department, is that we want to professionalize the municipalities, which is very correct. But we must not lose sight of what is happening, the real situation, the real problem that caused these municipalities to be dysfunctional is corruption. The second point that I want to make, in reference to the presentation made by SALCA, when they painted a picture to say that it does not mean that when we have permanent workers, it means that the problem is solved. I also raised this point, Chairperson, last time when we discussed this matter, to say all of us here, irrespective of political parties, we are very concerned of what is happening. And all of us, we have taken a posture to say that let us, rather than saying that it's ANC who's failing, but let us all come with sort of solutions, because even if it's ANC who's failing at a municipality level, but as a citizen of eThekwini, I got affected as well. So therefore, let us all put together our heads to come with solutions to this problem. So therefore, I'm saying, Chair, to take care of our workers is a good thing to do. And secondly, we said, or I said, we need to strengthen the capacity of each municipality now to deal with internal processes. Because the dominating view last time was to say that if we agree to amend that particular sections that will make senior managers to be permanent, and they will be accountable to municipal managers who are not permanent, it means that the municipal managers will be forever undermined by these people who are permanent now. They will say that you will find me here and you leave me here. So it means if they don't want to cooperate with the MM, we said to the department, please share with the intervention strategy, the policies that will talk to that particular concern as a committee. Because at the end of the day, we must not have anarchy, and the department must lead us in that regard. And also SALCA must also help us to say that if we come across with such a situation, what are policies all municipalities will put in place? And the third aspect that I also want to engage with the committee chair is this issue of a fixed term contract. The issue of a fixed term contract, Chairperson, it's a problem. Even if we can say that there's an amendment in terms of the Labor Relations Act, Section 198B, they're trying to address those challenges. But most of the time, the labor court does not have a fixed problem when they deal with the fixed term contract. It's a really problem. So therefore, as uhulumeni, as a government, it can't be correct, it can't be political correct to say that our people, they must be subjected to the fixed term contract forever. Especially if you are saying that it's because they are going to undermine those people who are in a fixed term contract. So therefore, that's why I understand very well when Salka said, instead of addressing this thing in a piecemeal, let us address it broadly, to look at a broad level or holistically this amendment. It will help us a lot because our problems are many. And the Labor Relations Act, most of the time, they relied on the court, the labor court, when the judges are pronouncing on each case. For instance, here, our legal advisor here, if you remember, Chair, she used many court cases here. And when you go and also check in terms of the Labor Relations Act, that is the case as well. The judge on this case have ruled. The judge on this case have ruled differently to that one. So it's an ongoing problems to try to fix a problem of fixed term contract. So therefore, I totally agree with Honorable Hussein to say that we need to have a political will. And I thought that the department was going to assist us in that regard to say, okay, they have presented in terms of consultation, which is, is good to get a sense, we get a clear picture. But when it comes now to each and every municipality, if you remember very well, the two documents or the two presentations from Salka and the department does not talk to each other. The DDG, Tebogo, is saying that particularly in eThekwini municipality is a number of people who are permanent and there is good result on those bases. When Salka comes, they said, no, that is not the case. And then they put slides here. So I agree with Hussein to say that I would have thought that Salka and the department will have sit down, like they do. Remember, Chair, when we were dealing with the water pots, Salka, the department, were coming with various aspects or various opinions, and we said to them, no, go and sit together. We need you to come together and come to these joint political committees with one voice. But it's fine because it also helps the members of the committee to take an informed decision on the basis of the two presentations that does not talk to each other. But I'm saying that the department is telling us that no, there is positive things according to these municipalities that are a part and parcel of ILGM, and Salka is coming saying no, that is not true. But the mere fact here, the standpoint here is to say that we can't punish our people on the basis that in South Africa, the rate of unemployment is too high, and the government is also contributing in terms of hiring people to have jobs. And as individuals, Chair, and as mothers, as fathers, as parents, we also have children. So I don't think that I'll be very happy if my 13-year-old girl, when she have arrived to the stage whereby she's looking for a job, and then now there is a law or there is an act that me as her mom agreed that when she go and join the labor forces, when she comes back home and said, hey, my mom, I got this job, but it's not permanent. We must think futuristic. We must not think now. So that's why I'm saying those challenges that we have in the municipalities, it will need clear policies, human resource policies to deal with those things at municipal level, because we can't accept an anarchy whereby we are going to be told that in this municipality, there is a problem of a senior manager who does not respect an MM on the basis that the MM is not on permanent basis. Those are the petty issues that needs each municipality that needs the department to attend to it. I mean, we're also coming from political parties whereby we have staff members here, and we don't accept anarchy in our political parties. So we address those issues through the policies. Even here, that could be the case. So let me pause, Board Chairperson, and hoping that we still have to engage as committee members, but I want to make it very clear that let us allow our own people. It's good, especially for young people who want to join the labor force, to become permanent. Okunye nokunye okungama-challenges will address as we go. But we can't be saying to our people, no, you must be slaves forever because you are going to undermine the MM. Thank you, Chair.
Thank you so much, Honorable Mkalipi. Honorable Direko. Yes.
Thank you, Chairperson. I've seen the consultation done by COCTA, but I'm still of view that the consultation is not good enough for us to take such decision. And looking at the two presentations, you can pick it up that there was no proper consultation between COCTA and SALGA. And it makes one question the method of consultation, because when you speak of local government, the first point of departure in consultation should be SALGA, should be labor movement in the municipalities. So I just want to check if was there any consultation with SALGA before the decision was taken, before the proposal? Was there any consultation with labor movement before this proposal was brought to us? And secondly, Chair, I think it's Honorable Pesa who was saying, looking at the SALGA presentation, there is no guarantee that the good performing municipalities are as a result of the permanent position. In my experience, for the municipality to perform, it's for good governance and other factors. So if they're saying that it's because of the permanent position, which guarantee do we have that it's because of those permanent positions? I also need clarity on that matter. And I think, Chair, the presentation of SALGA gives us hope. It's the realities of what is happening on the municipalities. It's not biased towards any particular view, but it's an open-minded presentation. That needs us to think thoroughly through that presentation and make an informed decision. Chair, if I'm arguing that the consultation is not enough, I'm not saying people should not be permanent, but I'm saying this because our systems down there are not ready. We need to understand that as much as we want this, but there are realities that we are facing on the ground level. So I think the proposal or the proposal that was mentioned or something, it was mentioned, I think, by SALGA, whereby they said that maybe we should also explore the possibilities of each and every municipality deciding for themselves, so that at least, because the situation of municipalities differ from one municipality to another. And in this situation, I think it will be better if we treat each case by its own merit. Let's not apply a blanket approach, which will come back to haunt us. So my proposal, and the other issue on this proposal, Chair, it speaks about only senior managers. Are we not creating an elephant in the room by the name of the MM? If the MM is not permanent, others are permanent. What are we saying about this elephant in the room? Should we agree to this proposal? So now my proposal, Chair, is that can we please have a comprehensive consultation and allow COCTA together with SALGA to sit together and meet with all the relevant stakeholders in the municipalities, and thereafter come back to us with a consolidated proposal whereby it does not disagree with one another. Thank you, Chair. That's my submission.
Okay. Thank you, Honorable Direko. The next speaker, my apologies, it's Honorable Brink.
Thank you, Chair. With your permission, I'm not going to switch on my video. because
Okay,
my
it's fine.
internet connection is not at its best.
Is the power back?
The power is back indeed.
Oh, that's
And
glad.
I think Honorable Hadebe is in the same place as me, so his power is also back. Chair, I think we can draw 3 conclusions from what has been presented to us. And I don't necessarily agree with colleagues what all of the conclusions they've drawn, but this is what I see. Number 1, it's apparent that there's no legal impediment to the proposal of making Section 56 permanent. It's not a labor or constitutional law impediment. You can do that freely. I think, as is the case in the National Public Service, where the official at the top is 1 or 2 of the layers at the top are on fixed term and the rest are permanent. The second conclusion is that COGTA, the national department, consulting various provinces and taking into account international experience, give their advice that the permanent appointees on that level is better for governance in the long term. I don't, I'm not a member of this government. Chair, I'm in the opposition, so I'm not directing any of this. I just have to listen to what they say, and the argument sounds plausible. And the final conclusion, Chair, is that SALGA has done a survey of its members, and its result is inconclusive. It says that some municipalities that have fixed-term Section 56 appointees do well, and some that have these permanent appointees don't do well. Some of the clean audits are on the side of these municipalities, others are not. So in essence, it's a neutral outcome. It's neither here nor there. So SALGA falls back onto its original position that municipalities should have the choice. But I don't think SALGA has made the point that their research points to sticking to this current status quo. It's just because their survey hasn't given them a persuasive, clear answer either way. So I think it's important to make the point that let's not make of SALGA's position more than it in fact is, which is a neutralized position. And going from that, Chair, we can say that we need more consultation, which might be a good point. But maybe this isn't a point of consultation. Maybe we just don't agree on the conclusions, but to say we need more consultation in the hope that, I'm not sure. This legislation has been dragging on for so long. It's got serious implications for the future. We need finality. Parliament and government is way beyond the timeline that the Constitutional Court gave us to fix this. So I'm not entirely sure that more consultation beyond what was already presented in some fair amount of detail would be of any utility. Maybe this, it's just a difference of policy or opinion, but I don't want to preempt that. So those 3 conclusions, Chairperson, and then in response to what Lance has said, 2 important points, I think. The one is that, in fact, this is a question I want to put to Lance as well as COGTA, SALGA as well as COGTA. The first is that having a whole lot of fixed-term contract positions is premised on the availability of a large pool of people who apply for these jobs and have the necessary skills. So they come into the positions, they go out, there's a big availability. And by extension, it means that we think that people who are in the private sector will also apply for these jobs. Because that's what this idea of having fixed term contracts in the public sector is premised on, so that the public sector can benefit from people who move from other sectors, and that there's this free interchange of skills. But and this is why I'm asking Salga and Cogta, I think we can agree that that is not the position. The local government sector isn't very good at drawing people from the private sector to come and work in fixed term contract positions for government. The barriers to entry to serve in a Section 56 position in terms of your regulatory exams that you need to pass, the qualifications, it's high. It's usually public sector people, whether working for municipalities or for other spheres of government, that apply for these jobs. Private sector people don't, for various reasons. And so if that premise for having fixed term contracts is removed, then it sort of prompts you to think of, should we not cultivate a specific, let me use this word, cadre of officials who are dedicated to public service. So a professional core of officials who work for government, who work in the public sector. Then lastly, to answer the question of why is it that we stick to a fixed term contract municipal manager but not direct reportees to the municipal, Lance was saying, why shouldn't we just make the municipal manager also permanent if the argument is to make his direct reports permanent? And I think the simple answer to that is that having the municipal manager on a fixed term contract gives the political leadership a lever over the administration. It is a lever that you can use and that you can change without disrupting the entire top management of the municipality every 5 years. So it is a more precise and more exact way of gaining that control. And then, of course, you have to have proper disciplinary processes in place. You have to have proper performance management processes in place. But that's also true of fixed-term contract employees. You can't just get rid of them. You might be able to pay them out. But in essence, the cost of getting rid of a poor-performing fixed-term contract employee is in essence the same as of a permanent employee. But those are my views. Thank you, Chair.
Honorable Hadebe. Honorable Hadebe.
Thank you, Honorable Chair. I will not switch on my mic, Chair, but let me welcome the presentation. Unfortunately, I did not get to hear other presentation, but I logged in on time to the essence of what the department was presenting, and I've had a privilege to hear the entire presentation of Salga, but I have gone through all these presentation before this meeting, so I got the sense and understand the gist. Chair, I am very impressed with the presentation from Salga, given the scientific nature and approach in relation to the data presented to us. In that they are giving us what's actually happening on the ground. And one must say, Chair, up front, that what Salga is given to us, it's not to say they are opposing the issue of permanent. It simply means that what we are dealing with, the situation in our municipalities, it's not a homogeneous situation. It's not a one size fits all. As such, municipalities won't be prohibited
from considering or adopting what they think is applicable and suitable for them based on the material condition in the different municipalities. Now, for us to adopt an approach that says, let us leave to individual municipality to decide what is the suitable and based approach for them, I think that will be a brilliant move. It's a common sense, given what the data was presented to us. There are negatives on those municipalities who have permanent Section 56 managers. There are positive as well, including those who have fixed term Section 56. There are positive, there are negatives. So as such, Chair, the only logical thing to do is for us not to be prescriptive. Let us not apply 10 commandments when they say thou shalt not steal, thou shalt not commit adultery. It is like that until Jesus comes back. Let us afford municipalities, those who are in the cold phase of service delivery, who understand their situation, and with the concurrence of the MECs, they will be able to apply and adopt a solution that is applicable to them. What I like about this solution, Chair, is that it does not prohibit them from adopting a permanent approach. It also does not prohibit them from adopting a fixed term contract. So in that sense, Chair, I think as and when the time is right, like Salga has put it, as and when we are ready, we can be able to move in unison, speaking with one voice. But for now, I strongly recommend or propose that we adopt the view of Salga. It's scientific, it's based on the current status quo and the material condition in each and every municipality. I thank you.
Thank you, Honorable Hadebe. The next speaker is Honorable Honevald.
Thank you, Chairperson. Chairperson, with your admission, of your permission, I would like to request to keep my video off. Although the power is back in Acacia Park, my lights aren't. So I'm sitting in the dark still. So if it's fine, can I keep my camera off?
Finally arrived in Cape Town.
Yeah, and I've been here since yesterday. Thank you, ma'am. Chairperson,
and how was the cruise?
It was a long cruise, Honorable Chairperson. So it's about 1,200 kilometers, so it's tough, if I can state it like that. Okay, thank you, Chairperson. Chairperson, I want to agree with the latter speakers. If you look, well, before I start, I just quickly want to ask Lance, in terms of his presentation, the 13th slide, if I can ask Andile to quickly bring it up. Slide 10, 11, and 12. Andile?
Andile, bring the slides. Or Lance himself is there.
Yes, Lance has got it.
So, Chairperson, the reason I ask is because everybody's referring to the figures, and I think it's important that we have clarity on it then. If you look at slide 10, you say that there's 7 clean audits out of the 52 municipalities that have permanent employees. If you can go on to the next slide. Lance, if we can go to the fixed term one. Chairperson, can you still hear me?
Yes, we hear you.
Yes, we can.
Okay, I'm going to go on so long, Chair, but on the next slide, it says fixed term contracts. And out of the fixed term contracts, there's 14 clean audits out of 207 municipalities. And then on slide 12, we put them next to each other and we say that The 7 municipalities is 33% of clean audits, and the 14 is 67%. I want to differ when you put those two together. If you have 7 municipalities out of 52 municipalities that have clean audits, you get a total of 13.46% of the total municipalities have clean audits. That's on permanent appointments. And on fixed term appointments, you only have a 6.6% or 6.7% of them that have clean audits. And then if you put those two next to one another, not as the slide in 12, then you get that 33.23% of your fixed term contracts have clean audits, but on your permanent contracts, you have a 66.76% of clean audits. So if you want to put the one versus the other one, I would say that we mustn't just take the numbers directly, because there's only 7 out of 52 and then 14 out of 207. So I've quickly calculated the disclaimer as well. I'm not going to do everyone, but the disclaimer, we say that on permanent contracts, we have 4 disclaimers out of 52. It amounts to 7.6%. And on a fixed term contracts, we say that we have 25% of 25 municipalities out of 207 that has a disclaimer. As the slide shows, it is on the calculation that Lance has done, is to say that 68% of those 25 of 68% is a disclaimer and 40% on permanent contracts. When I go and look at the calculation, when you put apples with apples together, you get that on the fixed term contracts, you have a 61.3% disclaimer, and on your permanent contracts, a 38.16% of disclaimer. So, Chairperson, if I look at the figures that Lance gave through in terms of the survey that they've done, it is quite clear that when there's a permanent appointment, you actually have a better, can I say, audit outcome. But then I also want to agree with Brink to say that it is actually inconclusive. There's not one that we can say is doing better than the other one. So my 2 cents that I want to add, Chairperson, is to say that doesn't matter to which side it goes, that whichever decision we take, we have to take into account that the taxpayers want value for their money. And that's why I want to agree with Honourable Kalipi to say that when we look at municipalities, we mustn't look at it in terms of political parties. We must see that it's all people on the ground that suffers when a municipality closed down or cannot do service delivery. And we must guarantee that it doesn't matter what we're doing, that we give value to the taxpayers in that municipality. Thank you, Chairperson.
Thank you, Honorable Groenewald. Honorable Kiwi.
Allow me not to use the video.
Okay.
Chair, let me also come in and really agree with the latter speakers to say whether it is permanent or it is a fixed term, let us really allow municipalities to see or to decide what is it that they want. I also want to check with SALGA because I'm really also impressed with the audit, with the work that they have done in terms of understanding what is happening at the local municipality level, because it's where things are happening. And I think maybe if we can check, because they, according to their survey, the audit outcomes are not really as what we have heard from the survey or maybe the report, the first report that we have received, is to say municipalities with fixed term contracts are getting bad audit outcomes as compared to permanent. Maybe if we can move a little bit back and check before those are that are having a permanent managers that are in those municipalities, what were the outcomes before they become permanent? And then we will also know what is it that we are going to do. And also, Honorable Chair, on the issue of if a person is on a fixed contract, knowing that at the end of next year, she or he might not have a job, I think I must disagree with that one. You know, whenever people I'm from a municipality, whenever people are on fixed term employment, they make sure that they do their best to get the job again tomorrow. I think really everyone wants to secure his or her job so that they can be also there in the next what you call when the new council comes in or at the end of their term. And also, we got here information about or comments from the Western Cape. I am not sure, we did not hear what are the comments from the other municipalities or the other provinces, as the Western Cape is now we are getting comments from the Western Cape. And you also don't know when was were these comments made, because the documents that are being attached does not have a date or a signature as to say this survey or maybe this was done on this date and also the other municipalities. So I'm saying let's allow the municipalities to look into the issue of do they want to employ their managers permanently or on a fixed term. But I know when municipalities were supposed to employ their senior managers on a permanent basis, it was difficult. But because they were really under the impression, or they were told that this is what is supposed to be happening, and then everybody had to follow suit. So I think if we can go down, or the department plus USALGA can really sit down and do a survey again and check into the municipalities, what is it that suits them most, then they will come up with something that will really clarify to us and say, this is what the municipalities are saying. I agree, when people are permanent, they are having a tendency to go and relax. So, Honorable Chair, I'm saying let us really allow USALGA and the department to go back, and also the municipalities to decide what is it that they want. I thank you, Honorable Chair.
Thank you so much, Honorable Kiwi. Some asking, who are you? But it's fine. Honorable Kiwi is our alternative member. Whenever she has time, she does attend this committee meeting. What's wrong with you? I'm ready to deal with that. And then
can I said, can I please add one point? My apologies for interjecting. There's something that I forgot to add. Yes, no, Chair. I wanted to say also, honorable members must bear in mind that these fixed term contracts are performance-based contracts that are reviewed annually, and such annual review gets tabled to municipal council. So in essence, Chair, there is nothing prohibiting municipalities from renewing these fixed term contracts if they're satisfied that those managers are performing and excelling in what they do. I wanted to add that aspect just so that we must not also lose it in our debate, that these are performance-based, they can be renewed based on the performance of senior managers. Thank you.
Okay. Let me also try to raise this. since our last meeting, I also did my own research, trying to understand these matters of permanent, fixed, and the rest. Pardon me for those of you who are from the coast. There's a municipality called Sengu. I wonder if I'm pronouncing it correctly, in the Eastern Cape.
Sengu.
Whatever, you have it. At least we're together. So, this municipality, if you check it, it has been achieving clean audit. There's been stability of management for the past 20 years under a single MM. This was done due to the council discretion. When his 5-year term ends, because the guy was performing, they will continuously renew it because the law doesn't prohibit the number of times that the municipal managers thing can be accounted. In fact, it's not only the MM, as well with the CFO. The CFO has been that municipality, if you have to go and check, for quite some time. So the issue which we are trying to, when I read and trying to analyze what this submission and the argument for permanent, there's a matter that I think we are not attending to it. The issue of turnover and institutional memory. It's one important key driver of success. You check the history of this municipality, saying good that I've indicated. It had 3 mayors in 20 years. It means the other served 2 terms. And their MM started as an intern. I'm trying to raise this issue if we are to talk about permanent. This person started as an intern. He grew up within the institution, and the council using its discretion to allow him to work up to this point. So I'm trying to advocate on somebody who's talk about the labor relations things to say, it means then the issue of growth, if you are to deal with that, you put these guys like Becky, who's in his 29s, to be a manager permanent. It means we need to wait for Becky to retire to develop other potential managers to reach that position. That's the implications of these things if you are to look at that to say. Then it means the growth within the institution will only up to managers, because even everybody is permanent up to whatever. So for you to produce other new MMs, then you'll have to wait until that layer retires. That's when you'll start to produce MMs. But I know an assistant manager can still apply to become an MM. But you know, in the public service, you don't need to do that, because that's the missing part I don't see. Because for you to become a director in a department, you need to have a particular period serving as a deputy director. The same with you to become a chief director in the government department. There's a particular period that you need to serve for you to become that's the missing link when I'm trying to understand that, so that you must then be able to qualify to be a DDG or a chief director in the government department. You know those. They will tell us. So the issue that I'm trying to raise here to say, if you appoint somebody permanently, then the issues of performances will also be threatened. Hence, we will prefer flexibility to use council's discretion to be given to municipalities. We're raising this because once you prescribe it, you'll only say your only option is the DC process. That's what somebody is arguing that. So I'm coming to this because Mukalipi was very vocal on advocating a policy on ensuring that the MM don't get also undermined. And then we've said that because in terms of all this presentation, we don't get this. We were told, in line with what Honorable Kiwi has raised, to say there are minimum resolutions to this effect. But the only thing that you see here you want to tell us it's only the Western Cape that commented on this, and we must go with that view without hearing also what the other provinces are saying. I really don't understand that on my part. Then I could have wanted to hear the views of the other provinces on these ones. And then in line with what has just been presented to us as well, including this report of the PDG that you have given to us, it's not talking about permanent appointments of these managers. It's only talking about MMs, fixed term. Then it doesn't talk about, but this is the research study that the department commissioned. It doesn't shed much light on the permanent appointment of Section 57 managers. Yes, we agree with what the colleagues are saying but there's a lot of factors that we did. In fact, where I'm seated now, if we should then work on this, I'll think, remember, when we started this bill, we were told there's a constitutional court, a judgment that we need to comply with. And that period lapsed for us as parliament. Then when it lapsed, then it means we shouldn't, then we will only, then we can, then the focus on the 2011 amendments, because we wanted to validate that only. But at the same time, where me and you are seated, we're now dealing with municipalities. There are a lot of challenges that they're encountering. So if we will then deal with this one aspect of appointment, because this is our tenure as in the visitor Lutuli has said. The other time during our induction, we were told that this white paper, 1998, it needs to be reviewed because I think all this legislation emanate from that, plus the constitution of the country. Why can't we then, under the circumstances, because to validate the 2011 amendment with these other circumstances, and then I think then for us, for the department also do a holistic regulatory impact assessment in all these legislations that affect. Because for us to deal with this, we amend this tomorrow. I don't think we'll have another time to do another amendment before our term. Even if we were to do that, we'll leave it incomplete. So for me, I think this suggestion to say then let's fix all the problems which we think we can fix during this term. Because on the issue of Section 57 managers thus far and the this legislation is still fine. The issue it was about, when we started, it was about these political rights. So this is a matter of permanent, it's just coming at the tail end. Initially, when this thing we're trying to validate what happens in 2011, we're only dealing with the issue of political, who should be politically active. That's the issue that we wanted to deal. So this one, you remember, it came at the tail end. And then that's when we were told it's based on this consultation. If you are to track, when we started deliberating with the bill and the track record on how we dealt with this matter was not there until at the tail end. But from where I'm seated, I think then, because I'm trying to match, I was listening attentively to all of you, to match all your inputs, to say then let's have a more comprehensive review. When we do that, then let's also have a timeline, and nothing bars us from introducing legislation on our side as a committee. You know that. So that then maybe we ask to have the technical expertise as parliament. The cabinet road was only this one of validating the 2011 thing. That's far now. We are back to the status quo prior to 2011. So these are some of the issues that I want the colleagues from Salga, the department state law advisor to comment on. Then post that, then we'll be able to come with a way forward on this matter. Over to you. I think Yolande, there was an issue raised by Honorable Kaiser. DCOG is a lot of us, and SALGA as well, it's a lot of us. Let's do it in that way.
Chairperson, excuse me, I cannot recall the issue that Honorable Keza had. Could I perhaps just ask for a repeat of that?
Honorable Kaiser?
Yes, Chair.
Yes. Remember when you started, you were referring to the state law advisor presentation. What were the issues?
Chair, I was asking about the same issues that I had raised pertaining to what SALGA had raised in relation to the guarantees between the municipal managers that account to the municipal manager. When they are actually employed permanently, because I didn't think that whether they are permanent or not will then translate to the erosion of the culture of corruption, as my colleague and senior leader Honorable Mkhalipi has alluded to. I didn't think that that will then translate to the erosion of the corruption, the mismanagement of funds and all those things in the municipalities, and that being the be all of the solutions that are pertaining to service delivery in the municipalities. Those are the issues that I wanted to be appraised on, Chair.
Chairperson, if I may, perhaps just I've also listened to SALGA's and to COGTA's presentations. We must just remember that we cannot legislate for every situation. So if I understand Honorable Keza correctly, it seems to be more of an issue regarding the implementation of the legislation. So what it comes down to is there are currently different interpretations of the Principal Act as it stands. As I've alluded to in my legal opinion also, even the courts interpret, especially Section 57, differently. So it is now up to the legislature to clarify the interpretations. As SALGA pointed out, also there's different interpretations even between SALGA and COGTA as to how the Act is currently interpreted. So in my mind, this is more of a political decision whereby, as some of the honourable members also proposed, SALGA and COGTA must sit together and decide how to approach this from an implementation point of view and from a political point of view, and how it would suit most municipalities. And then we can fit that into the legislation, but we cannot legislate for all of the situations. So we cannot legislate in a way that would guarantee that there wouldn't be corruption. And we cannot legislate to cover all of the gaps that's currently in the municipalities' implementation of the legislation. But we can give them options. We can give them options on how to implement the law. But for me, it's difficult to really answer to the honourable member's question, because I see it more as a political sort of decision that has to be taken by COGTA together with SALGA. And if there has to be more consultation on that question, yes, certainly. But I just want to clarify that we cannot legislate for all of those instances. And for now, it's just up to the legislature to clarify the interpretation discrepancies that there are. Because as we said, there's a definite differentiation currently between the municipal manager and the manager directly accountable to that manager. So it's a political decision whether that differentiation must be retained or whether they must be placed on the same footing with regard to their permanent or fixed appointment. But unfortunately, we can't put everything into legislation. We must just make it easier to implement for municipalities. I hope that I've sort of addressed the honourable member's question. Thanks, Chair.
Okay. Honorable, we are coming to DCOC now. DCOC.
Sorry, Honorable Chairperson and members. I think I will just respond to some of the easy things here, and my leadership will then respond to some of the complex matters. But I just want to indicate, firstly, that there has been consultation with SALGA and also with organized labor on the matters that we proposed. There's also been a presentation, like I've already indicated, that was done at the technical min-meg and also at the political min-meg where SALGA was represented. And the bill, in the form and shape it is, was then presented to that particular forum. I just want to explain that there was that particular interaction that took place. But of most importance is to indicate that in one of the resolutions of MINMEC, at the time also when the minister of COCTA, and subsequent to that, there was a resolution by MINMEC that because we were now following this particular process of amending the Systems Act in terms of how it was in 2011, there should be another parallel process that is taking place that involves everyone, including SALGA, to look into the wholesale amendment of the Systems Act. But we need to prioritize issues that are there because of what I'll explain at a later stage. But for now, in relation to the issue of the wholesale amendment of the Systems Act, a steering committee was formed, and SALGA is also represented, and there is one body, also a person from SALGA who sits in the steering committee. And we looked at all the proposed amendments of the Systems Act and its regulations. And there is work that has been done, and there is progress in relation to what should be done, because just before COVID-19, we were to have a further discussion with what we call drafters to look into now putting bones into the issues that we discussed as the COCTA family that also included SALGA, so that when we have a discussion on the wholesale amendment of the Systems Act and its regulations, we are talking of a particular living document. So there's already been work that has been done, and SALGA is part and parcel of that particular steering committee that is doing work on the wholesale amendment of the Systems Act and its regulation. That's one point. The second point that I wanted to clarify, maybe in conclusion from my input from my side, is in relation to why even after the expiry of the period that was given to us by the Constitutional Court to go through the amendment as we had them in 2011, was the following: that there were issues that we included that are there in this bill now that at least made some form of professionalizing local government and making to it that there were minimum norms and standards set by the minister on certain issues. For example, competency levels of senior managers, having a database of dismissed staff, and also having regulations that outlines the process in relation to qualifications of people to be appointed in senior management in municipalities, and also included the process of appointment that also had some sort of measures to look into MECs, to also have to look at the processes that has been put there to appoint senior managers until up to the minister and up to us, the minister, in instances where there is no compliance, that there should be an approach to court for a declaratory order. So all those other things were institutionalized in order for us to appoint senior managers. And we have seen that through that particular process that was done in 2011, that particular process, we have made it possible for us to look into whether the people who come into the sector as senior managers are qualified or not. Now that has been institutionalized. Now the illegality or the unconstitutionality of that particular process will then make municipalities, and this what is happening now. This is what we had a discussion with SAGA in relation to how we are going to deal with this. Because we thought that if this particular first process of trying to bring back that particular institutional process into being, we will be in a better place to monitor the appointment of senior managers and to see to it that only suitably qualified senior managers are appointed. But in the absence of the 2011 amendment, we run a risk now that municipalities are now not even reporting to MECs, and MECs, as a result, are no more reporting to COPTA in relation to the processes of appointing senior managers. Now, our aim all the time was to see to it that even the last administration that was handling this particular process that was then taken over by this new administration was to see to it that if we can then deal with this particular process of 2011 as is in this new process, and at the same time, we allow the process of the wholesale amendment of the system sec to continue and fast track. Because when you look at the process, and I think another way, when you look at, I'm sorry. In conclusion, when you look at the process of this second portion that I'm referring to, of the wholesale process of amending the system sec, it may take a longer period, and in the process, in the absence of us having, of Parliament having gone through and finalizing this particular bill, we will have some sort of a lacuna in relation to us having that institutional arrangement continue. We are having a discussion with SAGA, like Lance has indicated, in relation to what then should be done. But our main priority was in relation to it. I thought that I might have to explain that so that the issue that honorable members are raising of we need to look at the whole municipal system sect, and also the structure sect, which is also already in the process of being going through the parliamentary process. We felt that in the absence of this, we might have a problem in relation to seeing to it that we appoint competent and relevant people, because in the absence of this bill being finalized, municipalities may appoint any other person because we do not have competencies that has, because the minister will not be having those regulatory powers that were given to her in 2011. And that may take, for example, the process of this wholesale amendment of the system sec may take 2 to 3 years. That may create a problem for us, monitoring the appointment of senior managers. I thought maybe I wanted to clarify that. Thank you.
Salga. Salgam.
Lance will start, if with your permission, Chair.
Okay.
Thank you very much, Chairperson, and again, appreciation to members for the contributions and questions that came through. I will first start by focusing on the member-specific questions to ourselves, Chairperson. The first, I thought Honorable Brink directed the question to us, making a specific suggestion and then asking a related question, and it relates to introducing professionalism within the local government space with a particular focus on broadening the net in terms of creating or making local government attractive to those that are in the private sector. And indeed, are we attracting people within the context of fixed term contracts, particularly people from the private sector to municipalities? I'll answer in two ways, Chairperson. The first one is certainly with the benefit of what is happening in the municipal space. I can indicate to Honorable Brink that there are a number of people from the private sector that are joining municipalities. And many of them, and if you would like, Honorable Brink, we can provide you with that detail so that I don't appear like I'm waffling and or I'm making up things as I'm responding to you. But there are a number of people that are joining municipalities from the private sector and are joining on a fixed term contract basis, and we'll provide you with such details. But also, there is a point that we had made around professionalism, and I think we have not moved as SALGA from that point. We remain an advocate for introducing professionalism within the local government space. We also, as we are advancing that position, we are also realists, and what as realists we have to recognize is that there is a particular contextual reality that finds expression in a municipal space. And we thought we were raising it, Honorable Brink, through the second last slide that we had presented. When we are saying, why are we saying that a different thing applies for municipal managers? And you also made an attempt to address the issue. But for me, what informs that reality of appointing a municipal manager on a fixed term basis and linking, by the way, linking his employment with the current council or the council that appoints him is indicative of that reality in a municipal space. Now, I want to ask the question without necessarily expecting an answer, Chairperson, but I want to ask a question, but also answer it in the same time, in the same space. Why is it that that does not apply at national and provincial level? Why is it that in a municipality, a municipal manager's contract is linked to a council? Why is that a DG, whether it's at a provincial level in a premier's office or a DG in a national government department, or let's take it further, in the presidency, why is their term of office not linked to the leadership at the time? So why is the DG in the presidency's term not linked to the president or the current cabinet? Why is the DG in the premier's office, why is his contract of employment or appointment not linked to the provincial cabinet and or the premier? Why do we then want to do it at a local government level? And the reason why we're asking that question, Chair, within the broader context of an overhaul of the Systems Act, is because we feel the answers to those questions are no different to the answers at the local government level if we truly look at them for what they are. And therefore, we need to take a broader look at the things we want to introduce and are introducing at the local government level, but they don't find expression from a principal point of view at a national level and at a provincial level. And you ask the question, why? Why is that the case? And my fear and our fear as SALGA Chair is that if these amendments go through, we will be stuck with that reality. We'll be stuck with that reality that we would have to manage at a local government level. We would have to manage it at the local government level. It is not going to be others who are going to manage it for us. Local government is going to have to sit and be stuck with that reality that is now being forced upon them. But the other point we wanted to make, which we made this morning, Chairperson, in the meeting of the Portfolio Committee when it engaged with Dr. Bear's North-Deer municipality, is that even where we have professional bodies, where people are subscribing as members and they have to meet the prescripts of those professional bodies as part of advancing professionalism, it has not been a solution. And this morning we presented to you that there are, when we met with SAICA 2 weeks ago, they told us about how many of their members of the Institute of Chartered Accountants. The Institute of Chartered Accountants has members that work in municipalities. And we asked them the question, so if you are a professional body advancing professional ethics, why is it that your members are part of the wrongdoing in municipalities? And what are you doing? What are you doing as a professional body to ensure professionalism from your members? Why do your members, why are they part of the wrong that finds expression in municipalities? And what are you doing about it? So it is not an easy fix to say, well, let's create professional bodies and create professionalism with those bodies. It is what we do when we have those bodies. Are they doing what they ought to be doing, and are they advancing true professionalism within our space? And certainly from where we are sitting, based on the information available, that is not the picture that we are presented with. And the same we could be say with ILGM. We are scheduled to meet with them this coming Monday. The question we are going to ask them as well is, your members as ILGM, they are in municipalities where things are happening that are negative. What are you doing? So the same questions we have to answer as SALGA about municipalities and the wrongs that are happening in municipalities, we are now also asking the very same professional bodies who have members in municipalities to take responsibility for what is happening that is negative in a municipality. The second point I wanted to come to, Chair, is the proposals that are made on the survey conducted. Certainly, we would want to take on board, in particular, the suggestions made by both Honorable Hussein and Honorable Kibi. Honorable Kibi is from the local government space, so she understands it very well. The points that are made that our survey could have taken a few more steps further and or explore a few more things. We will take that on board, Chair. We will go and do that work because it will amplify work that we have started in July. And then also in response to Honorable Groenewald, our calculation on the percentage, comparatively speaking, between permanent and fixed term, what we have done, we have isolated the clean, we have isolated the qualified, and similarly the other categories of audit outcomes, and the percentages are linked to that. You are presenting a different perspective. We will also include that as a different perspective in calculating percentages. But in our view, it will not move us away from the conclusion that we are reaching, that many of the members have confirmed through their contributions after our input, And indeed, we are not shy to say that what our survey is saying to us is that there are two sides of the coin. So it does not say there is one preference. It does not say that. And it confirms and reinforces the point that we're making. If there are two sides of the coin, and if there are positives and negatives for both of sides of the coin, do we really need to, at this stage, do we really need to move away from where we are? Or do we rather allow things to happen, but we run a parallel process of ensuring that we address the weaknesses that we find on either side, and maybe come to a stage where we are ready to say, well, all indications are that the best route to take is this route. And why is this the best route? Is because we had fixed the underlying weaknesses of this particular route that we would want to take. We feel that the survey confirms to us, we are not ready to take a different path. We are not ready for that path. And I think it would be an injustice if we take that journey knowing the weaknesses, and downstream we have more problems and unintended consequences than what we have based on the picture before us. Then two issues that were not raised by members, but I think it's comments that are coming from COCTA, the chair. We will stay away from conflict. And our response, if you would allow, Chair, we would rather, so that we speak based on facts and we do not just talk because we have an opportunity to talk. We want to respond to yourselves in writing on two things that are being raised. Issue of consultation, we will respond to you in writing factually. Issues around committees that have been established, we will respond to you in writing factually, Chairperson, and I would not venture into those areas, but if you allow us an opportunity, we will indeed put it down for you in writing, including, Chairperson, there are conversations that have taken place around what we had, and it's not new. We had proposed to COCTA what should happen in the context of the vacuum of the 2011 amendment being invalidated. We have made proposals to them. It is a subject matter of a conversation. We do not think that all is lost with this invalidity of the 2011 Amendment Act. We do not believe. We do think that there's an alternative to address the weaknesses of the invalidity of the Act. And I think COCTA is well aware of what those are. We have not been shy in expressing those, but we would also, Chair, in writing, advance what we had advanced being the solutions to the current vacuum, and rather take the route of an overhaul of the Systems Act. Thanks, Chair.
Councillor Stofile.
Thank you very much, Chair. Probably I must start by saying you allow DG in the presidency and DG in departments and in the province because of the understanding that the state is an instrument that must continuously service the public. And unfortunately, in local government is not seen as a state, the local state. And that is why you see some elements of attempting to treat the local government as a tier of government, not a fully fledged sphere of government, that it had to be supported, it had to be assisted in going through the difficulties. I think that is the understanding, and that is why you won't see regulations pertaining to or laws pertaining to should be the DG in the presidency to be permanent or full-time or contractual basis. So I think we should understand, and that is why there is, in the theory of the state and government and the separation and its role and its politics that it needs to engage on, it's what is understood, but unfortunately is not really fully understood in the local government. And I've heard all honorable members saying they have been councillors, and I'm happy for them to be councillors in their life before they come to the House. I don't know, did they ever heard of a story where a manager reporting to a municipal manager saying to a manager, you are only here for a particular time, you are going to go out and then we are going to get a new person. Do we think that that attitude does contribute to the professionalization? And in my sense, it doesn't. And of course, it requires some level of commitment of professionalization of the sector, the local government sector, so that local government sector does address the challenges faced by society and communities, and most of those challenges, as alluded to by the what to call it, by the committee members that participated in this meeting. The issue to me, Chair, is that what will be a problem to put rules in which local government must respect with an intention of supporting local government to achieve its own objectives as enshrined in the Constitution. And for instance, you are making a perfect example, Chair, on Sengu municipality, which is not mentioned, unfortunately, on the study that has been presented by Cooperative here in this evening. Sengu, having realized the performance of this municipal manager who started as an intern, decided as a council that this intendant must grow. Can you imagine a situation if this municipality has no ability or has no authority to choose either to take that route or not to take that route? Where could have that municipality be today? Some of the things that we are doing at times probably we are doing unintentionally, unwittingly, but they have far-reaching consequences. Sengu today is one of the municipalities that is the stability, the leadership, the focus, the better focus on matters that affect the community, including a better audit outcome and a better service to the community, with the leadership that had a discretion to say we can't let go and lose this institutional memory. Now, as you manage this contradiction, I think the state law advisor said, which I fully agree with, you cannot regulate everything. You cannot put law if a person wants to go to overseas and say there's a law to go to America, there's a law to go to Britain. She said, in these issues, you need to deal with them and give clarity at the political level, so that we in the local government be guided in terms of how we then deal with these issues. In fact, it's a best option, and fortunately in the members here, they do have friends in the private sector. And part of the performance in the private sector that all of us, we are always saying private sector is a better sector than the public sector, is that how they link systematically the performance of each and every individual linked to the business in which the individuals are employed to perform. And it is important that whatever that we do, Chair, we mustn't create two families that ultimately will conflict and fight over. I mean, you can look, for instance, COCTA, it has been a high turnover of ministers over the last couple of years. And that is why earlier today you were talking about putting graves together. And we hope that there will be life. Because those that have permanent employment, indirectly, they undermine those that are there for a particular fixed period and leave. The productivity, of course, it will be affected. The performance of the organization, it will be affected. And that is why we are saying as an association, it's better be safe for now until we have some sense of what is happening in the sector and intervene promptly. And part of that safe is to say, let the municipalities have discretion about what they want to do with this individual. If he performs, he remains. If he doesn't perform, we then upgrade it to this level. I think in that way it's going to help us a big deal in addressing some of the challenges that we face in local government today. I think, Chair, let me stop there. That is our take as SALGA. Of course, we will continue engage with the department, with whoever that has an interest in the local government, because we have taken a decision that it cannot, on this term, as we complete the 20 years of local government, we still have local government that is not performing. So if we agree on that, it means we can go as far as we can in changing the conditions that are faced by our public and communities in where we are operating. Thank you very much, Chair.
Much, Councillor Stoffel. Colleagues, it's now, what is it? Almost 19 minutes to 23 hours. I should think on the side of our committee, we've done justice to get all the information that we were required. And then some of you are still promising to send us further information, Lance, which we appreciate as well. And then I should think now, this also, whatever you have submitted to us, all of you, it can assist us to come to a conclusion on these matters. But I think also what is very critical is this one, that I think the main issue with this bill was about the issue of the political rights, which all of us, I think, we have managed to deal with extensively as this committee. We have already reached a common ground on the main area of contention in the bill, which was the limitation of the political rights, limitation of political rights. And from where I'm seated as the chair of this committee, I think we have then had these issues and exhausted the matter related to the fixed versus permanent contract. And then we still have to deal with more clauses. And I think from where I'm seated, these other clauses will be then fairly easy for us to also reach consensus on. And then also, I didn't hear any view that says if we are to retain the current status quo and allow the municipality to exercise the discretion, this will cause harm. So I didn't hear it here. Somebody will say this will cause harm because already it's legislated and there are things that has been raised that has to deal with this. So then what is left for us now because we've heard both parties. We still welcome additional information if it's to be finished to us. Because what we are going to do now, what is left for us is to go clause by clause through the bill with the proposed amendments, and we'll be formally in a meeting wherein we are agreeing or not agreeing on the proposed amendments. And we can't be doing it now because already we've exhausted our meeting time by almost 45 minutes. So I've since asked the committee secretary as we're deliberating, realizing that if we were to start that clause by clause, it means we're going to knock off tomorrow, because there are matters that we know that we are not on this other issue of the permanent. There are divergent views on that one. It means then we'll have to deal with that to agree on each one. So I've asked the committee secretary, and she gave me a slot here wherein we're going to finalize the deliberations on the bill on Friday, the 28th. Immediately when we finish with Lekwa local municipality, we're going to do, we'll go clause by clause. Having taken the advice, it also gives us the opportunity to dissect everything. And then as we deliberate, then going clause by clause, I'll listen to all of you. Then if we agree, we'll agree. If we don't agree, you know how we go about that. Then we deal with the proposed amendment. But bearing in mind that currently that view to say, well, let's leave it to the municipality to decide, it can assist, it won't cause any harm. But if I'm wrong, I'm not right, we'll also take that for a decision by the committee. The other issue that we can't leave unattended, we want to direct you, DG, and the team to start the review of the entire legislation, local government legislation. Because what we are doing here to deal with piecemeal is not solving the problems. You have seen how amalgamation has been made. The demarcation board is an act of this committee as well. If it means us to also look at that. So the holistic, I think the parliament advisory team and the state law advisors can also assist us as a committee. If that is not possible from the department side, this our the own bill that during our term we can also then look at that as a committee. I think I can sponsor that proposal, or Mukalipi can sponsor that proposal, or Honorable Hussein can sponsor that proposal, or Ndabezita literally can sponsor that proposal. And given our track record and experience in this committee on our commitment to make local government a better place, because if we then you have clear legislations and policies, we wouldn't be sitting here up to this time of the night. You can see the whole of this week, we're going to be knocking off this time. Next week, this time again, because then it will give us an opportunity to also then assess that what is it that has been working over the last 22 years since this local government white paper that you've brought into existence of all these other legislations. So that holistic review, and it must happen in our lifetime, Davizita, as you said. You don't know whether you're going to come 2024, whatever, but at least the legacy that will be remembered of, to say during our tenure, we've managed to fix the legislations that then will, at the end of the day, make a local government function. So this is how I'm proposing that we need to end on this meeting. We have a slot on our program. That day, we agree, we disagree. That's where we'll know each other's colors that day. So that I'm gonna make sure that we go close by close. But on this issue of permanent, I think it took us, if it's not 4 to 5 committee meetings, I should think we've Yes, I'm sorry, my apologies. My network was going. But that's how I want us to conclude this meeting tonight, colleagues. Tomorrow it's another early morning. I know Lance is not complaining. What normally Lance has been saying to us, Chairperson, you're keeping us busy until midnight, and then you want us to be functional again at 9. Unfortunately, this is a consequence of some of the legislations that we are seated with that makes us to work the way we are working. But I should appreciate you, colleagues, the commitment. None of you have left this meeting since we started. And these are unholy hours. But it shows commitment. That's one thing that also gives me hope. We are going to fix this, all of us together, jointly and collectively, so as we've always done. Can I be allowed to attend this meeting until we meet tomorrow morning at 9, please?
Thank you, Chair. Seconded.
President, Chair, we don't have a meeting at 9
We don't have a
tomorrow.
meeting at 9. It's
Starting at
caucus.
7.
We can sleep.
Oh,
Yes, we
hey.
can sleep finally.
I was worried because this thing of waking up in the morning is a challenge. For a change.
It's only me, Chair. Programming at 8:30.
Poor you, asking.
I can get down.
My shut up one.
But it's a month, it's Women's Month. She must do what she's doing for all of us. At least we know we are represented in that programming committee.
Exactly.
Maybe that's the reason why we are having so many slots in Parliament. It's because of that.
We are misrepresented. We can't be having so many.
Yeah, I didn't hear that one.
Bye-bye.
Good night, everyone. Good night.
Good night.
Good night, everyone.
Bye, Mkhadi.
Bye bye.
Tomorrow evening, 19 hours.
Good evening, Chair. Good evening, Chair.
You're still here, Brian.
Yes,
Still
Chair.
here.
Yes, we're here, Chair. We here, Chair.
You are here.
We are here.
We are here.
Long day, Chair.
Yes, for the bishop to pray for us so that we just go straight to bed. Good night, everyone.
Thank you, Chair.
Good night. Good night.